portion. I'll place 18 minutes. Even otherwise on merits also, the courts below have heard in past.
Mr. The 17 may be a debatable legal proposition, because otherwise you'll have to then file two separate suits.
In fact, please have 25, last 5 lines, and then their lordships considered Anatula Sudhakar and said that once in this particular proceeding, the title has been considered, then there's no question of relegating me. Just please have page 141 of the report. Actually, page 140, I'll begin with para 25. An injunction is a consequential relief, and in a suit for declaration.
You're not a plaintiff. You're not filed any cross objection.
I'm most glad to. And
you're not filed a cross objection.
I haven't, for the simple reason the suit has gone into the.
There are two facts. There are two things. One, there is no cross suit by you. Question of possession is always a question of fact.
I'm obliged to.
Physical possession is always question of fact. There's a term called settled possession, which probably has been undefined.
And that's what has been used by the Honorable High Court.
That's undefined. To be very frank, undefined by most judgment. Probably saying that it continues possession over a period of time, which shows that it's not being challenged or it's not disturbed. You can take it as settled possession. It's not a fleeting possession. It's not something which you do merely as a licensee. Something more than this possessory right which you claim and which you have don't actually to exist. That's the best way to define it. Beyond that, I don't know.
Could your lordships, your lordships in this judgment dealt with the issue that your lordship put to me? Please have para 26 onwards.
Yes.
This is the question that your lordship put to me. So far as the submission on behalf of the plaintiff, that even if the plaintiff failed to get the declaratory relief and relief for cancellation of the sale deed and her suit for relief came to be dismissed, the plaintiff is found to be in possession. Therefore, the only remedy available to the defendant would be to file a substantive suit to get back the possession, is noticed only to be rejected outright. It is the contention on behalf of the plaintiff that once the plaintiff is found to be in possession, her possession cannot be disturbed except by due process of law, and defendant 1, though may be the true owner, has to file a substantive suit for recovery of possession. While considering the aforesaid submission, the decision of this court in Maria Margarita Sequeira Fernandez is required to be referred to. What is meant by due process of law has been explained by this court in para 79, which reads as under. Due process of law means that nobody ought to be condemned unheard. The due process of law means a person is in settled possession, will not be dispossessed except by due process of law. Due process means an opportunity to the defendant to file pleadings, including written statement and documents before the court of law. It does not mean the whole trial. Due process is satisfied the moment the rights of the parties are adjudicated upon by a competent court. In the said decision in Maria, the court has approved the following findings of the Delhi High Court in Thomas Cook versus Imperial Hotel. The expressions due process of law, due course of law, and recourse to law have been interchangeably used in decisions referred to above, which say that the settled possession of even a person in unlawful possession cannot be disturbed forcibly by the true owner taking law in his own hands. All these expressions, however, mean the same thing. Ejectment from settled possession can only be had by recourse to a court of law. Clearly, due process of law, due course of law simply mean that the person in settled possession cannot be ejected without a court of law having adjudicated upon his rights qua the true owner. Now, this due process or due course condition is satisfied the moment the rights of the parties are adjudicated upon a court of competent jurisdiction. It does not matter who brought the action to court. It could be the owner in an action for enforcement of his right to eject the person in unlawful possession. It could be the person who is sought to be ejected in an action preventing the owner from ejecting him. Whether the action is for enforcement of a right, which is recovery of possession, or protection of a right, injunction against dispossession, is not of much consequence. What is important is that in either event, it is an action before the court and the court adjudicates upon it. If that is done, then the bare minimum requirement of due process or due course of law would stand satisfied, as recourse to law would have been taken. In this context, when a party approaches a court seeking a protective remedy such as an injunction, and it fails in setting up a good case, can it then say that the other party must now institute an action in a court of law for enforcing his rights, that is for taking back something from the first party who holds it unlawful?
Before we pass a degree in your favor.
I'm so sorry.
We pass a degree in your favor. Will you execute it?
My submission is this. The question of the plaintiff went and said, please grant me an injunction protecting my possession against the true
Suppose
owner
you
of the
want
property.
Grant injunction, you can't. Will you be able to
I'm
take-
seeking a dismissal of that suit. I'm not seeking any decree in my favor. I'm seeking a dismissal of that suit. But the plaintiff. I'm most obliged. The plaintiff went to court saying,
Yes,
please.
what do you say?
My lords, a cross suit has not been filed. How can I be dispossessed?
So 1 minute. We'll simply dismiss your suit.
My lords, how can I be dispossessed? It has not.
No, we'll simply dispossess your suit. That's the end of it.
My lords, then I'm placing reliance on how the title has been accrued with respect to from adverse possession. My lords, may kindly see the judgment. I've given the citation. Please see. I have crystallized my title with adverse possession.
That is already rejected by the trial court. You've not filed an appeal against it.
My lords, we haven't. But the
Where is the
question of
the
fact, my lords, on a fact-finding fact has been in my favor
And
that
it's
I had
not
the possession.
Same title to a sale deed, which is a court.
1943.
That's it. And you
What
can't
it
claim
transpired-
things at the same time. There's mutual contradiction in the
My lords, what had transpired was that the Tehsildar had held in my favor. My lords may see the first document. The first document held that I am in possession. Please see, my lords.
See how clarified, no degree of possession, etc. has been passed by this court.
I'm most.
Legal remedies be left open, my lords.
We are not saying it.
My lords, my lords may kindly indicate that we've been living for the.
All, that's
I'm most.
My lords, this order may be construed that I
Same thing, judgment is
dispossessed,
outside.
my lords.
and the appeal is allowed in the courts itself.
Well, it's just-
Suit filed by
Legal remedies.
Antram and
Suit filed by Hari Prasad.
suit filed by late Hari Prasad, now presented by his legal representatives, will be treated as dismissed.
I'm most obliged.
My lords, my remedies will be left open, my lords.
That's all.
Possession, my lords. My lords, I have succeeded on the issue of possession, my lords.
That's all, please.
My lords, may kindly indicate we've been living our entire livelihood.
That's all, please. That's all.
Very well. My lords.
Yes.